Okay, council, do we have anybody who's not signing in on the Antaya versus Schulich et al. Case?
Good afternoon. I think we're all here, Your Honor.
Okay, good. I had another one set for 1:30 as well. So I just want to make sure I'm not having the wrong people in for the wrong hearing. Okay, so let's go on the record then. And as I stated, this is case number 2213998. And if I could just have counsel go around the horn, starting with plaintiff, and just place your appearances on, please.
Good afternoon, Your Honor. Emily Peacock for the plaintiffs.
Good afternoon, Judge. This is Matt Thomas. I'm here on behalf of nurse practitioner Schulich, Dr. Craven, and Kalkaska Memorial.
Good afternoon, Your Honor. Nick Artave on behalf of defendants Munson Healthcare.
Mr. Sullivan, you're muted. I saw you talking.
Thanks, Matt. I don't know what I was thinking. Good afternoon, Your Honor. Alan Sullivan. I'm here on behalf of Dr. Gunn, Dr. Saminsky, and Northwest Emergency Room physicians.
Good afternoon, Your Honor. My name is Connor Morgan. I'm here on behalf of Sound and Patient Physicians, Michigan P. LLC, Hospitalist Medicine Physicians of Michigan P. LLC, Danette Wells, PAC, and Elizabeth Hunter, DO.
Okay, thank you. We're on the record today for purposes of a status conference in this case. Just looking at the file, it looks like the parties did participate in mediation last month. That was not successful, but it sounds like maybe after a period of some additional discovery, the parties may want to try again. So Ms. Peacock, on behalf of plaintiffs, is that kind of where you guys are at, and what would you like to see for a scheduling order going forward from today?
We are currently circulating a date of September 18 for that second facilitation with Ms. Manis. I'm just waiting for, I know a couple people need to talk to, in terms of the defense attorneys needed to talk to their clients and get back to us. I would appreciate it again if that would go forward by Zoom. I'm in the process and should have dates for experts to go forward between now and June or early July.
Okay, so just for all defense counsel, based on what Ms. Peacock's just stated, would there be any objection if the court just kind of leaves discovery open for the time being, with the parties mediating in September, understanding that that date may not work for everybody, and I know you're still circulating that date, but then having the court set this for another status conference by Zoom, maybe in October, and see where we're at that point. Does anybody have any objection to that as a plan for going forward?
No objections on my end, Judge. That sounds reasonable and seems to make the most amount of sense.
No objection from me, Your Honor.
I have no objection, Your Honor.
No objections, Your Honor.
Okay, so I will put that into a scheduling order. I'll get that out to all of you. And then I'll also send out a notice of date and time for that Zoom conference like we're doing today in October. Are there any other dates or any other issues that anybody would like to raise while we're out on this call today?
None for me, Your Honor. Thank you.
I also have none, Judge. Thank you.
None from me, Your Honor.
Nothing further, Your Honor.
Nothing here, Your Honor.
All right, well, you guys really made it easy on me. I thought with all these people involved, it might take longer, so. Thank you for that. I'll send out those orders and we'll go from there. Everybody's free to disconnect. Thank you.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Piece of cake.
Makes it easy when everybody agrees on what they want to do.
And you've got the yellows this time.
This one, Jeffrey West.
Oh, no.
Was there any other filings in that one?
I don't think
We
so.
adjourned the last hearing to give
Yeah.
one side of time to file. something.
Everything is filed,
Okay.
that's been in,
As far as
and this
knowing,
just
so
has,
up to date.
yeah,
Okay.
yeah, it is up to date, unless it came in today. But that makes me think. 2275. Oh, here it is.
Okay, sir, on the iPhone, can you tell me your name, please?
William Short.
Mr. Short. I'm gonna place you on hold. I've got your hearing starting in just a few minutes at 1:45, so I'm just gonna put you back in the waiting room right now, okay?
Yes, sir. Thank you.
Thank you. Okay, and Ms. Bosco, you're appearing on the Bishop versus Cecil case?
Yes.
Okay, have you had any contact with Mr. Allant? Because I don't see him signing in.
Yeah, I'm guessing, so we actually filed a stay in this. So I'm guessing he probably forgot, to be honest.
Oh, yep, I see that
Um,
now. Okay, yep.
I just wanted to show up and make sure that you didn't think we forgot.
No, okay, thank you. I appreciate that. And yeah, we probably, given that order that the court signed, it looks like right at the end of beginning of March or late February. I think what we'll do then is just set this for another status conference later. Based on that order, everything stayed for 120 days. So we'll set it for a status conference at that time as a control date. If things are resolved, obviously then we'll take that date down.
Okay, and just to give you an idea of where we're at, we did attend mediation. There was a mediation agreement that was signed. It is contingent on the other side getting financing, so that's why we stayed it, to give them the opportunity to get all of their paperwork filed with the bank and whatnot.
Okay. All right, sounds good. Thank you for appearing today, and you're free to disconnect.
Thank you.
Okay, if I could have you both unmute, please. Thank you. We're on the record now in Short versus Short. This is case number 2414382. Mr. Short is connected by Zoom. And ma'am, are you Jessica Short?
Yes, I am.
Okay, so we have both parties connected by Zoom. I have this set as a date for a final hearing to enter a judgment of divorce in this case. Mr. Short, is that how you wanted to proceed today?
Yes, sir.
Okay, and Ms. Short, is that how you wanted to proceed as well?
I apologize, Your Honor. My dog was in the background, whom I just kicked outside, so I did not hear.
Did you want to proceed with finalizing the divorce today?
Yes, Your Honor.
Okay, so you both have submitted a proposed judgment that's been signed by both of you. And it contains some provisions for how you're going to divide up property. And I just want to confirm that there's a handwritten settlement agreement, and then there was also what's been labeled as an addendum that was submitted and signed by you both. Mr. Short, is that your understanding as well?
Yes, Your Honor.
Okay, and Ms. Short, that's your understanding too?
Yes, Your Honor.
Okay, and just looking through, I had a chance to read through your agreement prior to the hearing today. And the only thing that I want to make sure that I'm clear on before we go any further is there's some real property, real estate on Brockmeyer Road. And so there's a loan associated with that property. Is that correct, Mr. Short?
Yes, that is correct.
Okay, and the agreement between the two of you is that Mr. Short, you're going to keep that property, you're going to refinance it in your own name and remove Ms. Short's name from the loan, and then Ms. Short, you're going to sign a quitclaim deed giving your interest over to Mr. Short. Is that correct?
Yes, Your
Honor. Okay, and Mr. Short, that's your understanding as well?
Yes, sir, it is.
Mr. Short, have you already started that process of refinancing, or do you know where that part of it is at?
Yes, I have. I've contacted a couple of lenders. I have been approved with Forefront Credit Union. I'm just waiting because it was brought to my attention with my current lender. I could just do a release of liability. So I started the process with them on that. I've submitted all the paperwork, and now we're just waiting to hear back from their approval.
Okay. All right, and Ms. Short, you understand that I can enter this judgment that requires Mr. Short to get it refinanced, but ultimately I don't have any power to force any bank or lender to give him a loan. So, if for some reason there's problems with the refinancing, that's an issue that, the two of you would have to work out together. But the court's limited in terms of its ability to enforce that provision in terms of forcing a bank to give him a loan. Do you understand that?
Yes, Your Honor.
Okay. Okay, so it sounds like everybody's on the same page. So what I'm going to do is place you both under oath. I've got some questions that I need to ask each of you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hands. Mr. Short, you're the party that filed for divorce in this case. Is that correct?
Yes, sir, it is.
At the time you filed for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir, I have.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, sir, I have.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, sir.
Does that remain true today?
Yes, sir, it does.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
And as part of this divorce, you are not going to be receiving any alimony or spousal support. Is that correct?
That is correct.
And you understand that you would be waiving that forever and you would not be able to come back later and ask the court for that.
I do understand.
Okay, and otherwise, all your property is going to be divided up between the two of you according to the handwritten agreements that you've submitted to the court to be made part of this judgment.
Yes, sir. And it has.
Thank you. All right, thank you. Ms. Short, have you heard all the questions that I've asked Mr. Short so far?
Yes, sir.
And have you heard all of his answers?
Yes, sir.
Do you have any reason to believe that any of the answers he gave were not true?
No, sir.
Are you currently pregnant?
No, sir.
Are you asking to have your last name changed?
Yes, sir.
Okay, what are you asking to have your last name changed to?
My maiden name,
Can you tell me what that is?
Ratza,
Can you spell that for me?
R-A, T as in Tom, Z as in zebra, A.
Okay, thank you. I have to make that part of the judgment of divorce, so that's why I was asking for that. And do you agree that you're going to divide up all your property according to the handwritten agreements that you both have submitted prior to the hearing today?
Yes, Your Honor.
And you are also not going to be receiving any alimony or spousal support as part of this divorce. You understand that you will also be waiving that forever and will not be able to come back later and ask the court for that.
Yes, Your Honor.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. I find that the proposed judgment and property division is generally equitable. The court will grant the divorce, and I'm signing that judgment with today's date. That judgment is available for both of you if you want copies for your records here at the clerk's office. Ms. Short, because you are asking to have your last name changed and because the divorce is final today, your last name will be legally changed from today forward. So you'll need to change your identification and other documents, and you'll probably need a copy of this judgment to do those things. So again, that'll be available here for you at the clerk's office. Mr. Short, did you have any questions at all?
No, sir, I do not. Thank you.
Ms. Short, did you have any questions?
No, sir, I do not.
Okay, thank you. That's all for today's hearing, and you're both free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Thank you.
Hello, Judge. It's Jack Deegan.
All right. Hi, Mr. Deegan. And it looks like we have Mr. Miller connected as well. So we'll go on the record in case number 2214041. And this is David Blower versus Nicholas Jansen, case number, oh, I'm sorry, I already said that. Record should reflect both counsel are connected here by Zoom today. I have this set for a press conference. Mr. Miller, on behalf of plaintiff, can you kind of tell me where things are at and where we're headed?
Yes, good afternoon. So I would ask the court to set a jury trial date. We've been having settlement discussions. We did try to mediate the case in February. That was unsuccessful. We're continuing to talk. We've talked about doing an arbitration, but no agreement has been reached. And I think I would like the court to set a jury trial date. The case was filed in November of 22, so it's been pending almost a year and a half. And, you know, we may settle, but we may not. And I would like to get trial scheduled and on the docket.
Okay. Mr. Deegan, anything to add to that from your side?
No, I have no problem with that. I would ask for some time before we set trial. We've got a couple of depositions to do. And then I'd like a motion cutoff date a couple weeks before the trial. But other than that, I agree with Mr. Miller. And we are still discussing the possibility of a binding arbitration, but we're not there yet. So in the event we aren't there, I would like a trial date also, please, with some time. But not a ton.
Okay, Mr. Miller, how much I know you can't necessarily anticipate Mr. Deegan's side, but how much total time do you think we would need for a trial in this case? How many days of trial should the court set aside?
I would say 4, maybe 5.
Okay, Mr. Deegan, what do you think?
That should be plenty. I thought more 3 to 4, but it's all right. 4 to 5.
Okay. And Mr. Deegan, how much time would you want before the court before the court has those trial dates?
Well, I have trials in May and June, so I would ask for end of summer.
Okay, Mr. Miller, any objection to that time frame?
I would say July or August would work.
I think just based on my, my current trial docket with criminal cases having priority, I'm thinking it's going to be August or September before I'll be able to get that many days in a row. So I think that fits into kind of what you both are saying. So I'm gonna set it for that time period. And then if we have let's say a motion cutoff in July, is there any objection to that?
No. End of July, please.
Okay. And then typically what I do in civil cases is set what I call a trial preparation conference shortly before the actual trial dates, where we talk about, just any issues that may arise during the trial, how long we want the trial days to be, composition of the jury, how many jurors we want to sit, all those kind of nuts and bolts where we could discuss that before the actual trial dates. So I'll send out a notice of a date and time for that hearing as well. Otherwise, it would just be the trial dates. And then assuming that we have motions, we would hear those obviously prior to the trial. But other than that, that trial prep conference would be the date that the court would set before the actual trial in this case. So to the extent that there's any kind of settlement reached, I would just be relying on counsel to notify the court of that.
Of course.
Sure. Thank you.
Thank you, Judge. And we'll get these dates in the mail.
Yep, I'll put all of these dates into an order and get that out to both of you, along with the trial prep conference date and the actual trial dates.
Okay.
Anything else I can address for either of you while we're here on the record today?
Not for me. Thank you.
No, Your Honor. Thank you. Thank you, Mr. Miller.
Okay, thank you. You're both free to disconnect at this time.
Okay. Thanks, Judge.
Yes. Oh, your calendar? No, I'm sorry. I just have a calendar.
No, that's fine.
All right, your August would be the 6th, yeah.
Okay, council, if I could have you both unmute, please.
I should be good, Your Honor.
All right, thank you. And we've got Mr. Corcoran. Okay, good. All right, so we're on the record now. This is case number 2314111. Beckwith versus Spink. And if I could just have both counsel put your appearances on, starting with plaintiff, please.
Mike Corcoran on behalf of the plaintiff Glenn Beckwith, Your Honor.
Good afternoon, Your Honor. May it please Court Attorney David Gilbert appearing on behalf of defendant Ms. Free Spinks. She also appears via Zoom.
Your Honor, I have my client present as well in the with me in the room. So.
Okay, very good. So today is the date and time set for hearing on plaintiff's motion for entry of a default judgment. Mr. Gilbert, I didn't get any kind of written filing by you.
Your Honor, I believe where we're at is I received a phone call from Mr. Corcoran about the potential to settle. There are several issues, not only this one that's currently in dispute. So in speaking with Mr. Corcoran as late as this morning, we are hoping to resolve this next Thursday in a face-to-face meeting.
Your Honor, that is correct. We've agreed to one last adjournment of this. There is a couple of related matters. There's a district court appeal that actually you have jurisdiction over, and Court of Appeals case. So all of those, quite honestly, my client and his related client are desirous of trying to resolve. And we thought we'd give it one last shot face to face here. Hopefully cooler heads will prevail. Otherwise, I was going to ask the court does the court ever allow you to have a Kalkaska motion heard in Grayling? Because I think Mr. Gilbert would be fine if we got another date 2 or 3 weeks out. By doing it, we could do it over in your neck of the woods if we had to.
Yeah, I mean, certainly we could set up a Zoom hearing if the parties had no objection to that. And that doesn't matter where I'm at a particular day. So I'd be happy to hear it, when you guys feel it's necessary or would like to schedule it. I just would need you to contact my office to get a date and time, but I'm happy to try to find time for you whenever I can.
I will reach out to Ms. O'Rourke, and I can schedule one of the related matters for the same time so that if we can't resolve it, we can kill 2 birds at once and come over and have it on Zoom. So
right, he's correct. This would resolve. I think there's, as he stated, 3 outstanding issues.
Yes,
and this could very easily resolve all 3 of those.
Okay, well, I don't have a problem adjourning today. I'm always obviously in favor of the parties reaching an agreement that everybody can live with, as opposed to being forced to live with something that the court decides. So we'll adjourn it for purposes of today's hearing. And then I will, I'm just gonna set this as a control date for a status conference, maybe 30 days or 45 days in the future. With the thought that we'll either be back on a motion or to enter a settlement prior to that.
Yeah, I will contact the court to at least get a date before that, Your Honor. But I do want to confirm that we are going to meet on the 11th, right, Mr. Gilbert, at 11 a.m. Okay, and I'll have my client there in person. So.
Okay. All right, very good. Thank you. That's all for today, and all parties are free to disconnect.
Okay.
Oh,
Thank
man.
you.
Stupid.
Sounds ready to settle. Okay, we have somebody joining us on the phone with the last four digits of 2076. Can you tell me your name, please? Okay, not sure who that is. Ms. Lentz, you have your client there with you?
Correct, Your Honor.
Okay. And Ms. Neros, it looks like under Dave, is that you, Mr. Dalton?
That is him, yeah.
That is.
Can
Okay,
you hear
great.
us? Dave, can you hear us?
Looks like maybe he's got an issue with having his audio connected there. I don't know, Ms. Neros, do you want to give him a call or how do you want to proceed?
Yes, if I may, really quick, just try giving him a call.
Sure.
I'm on now.
There you go. Okay.
Oh,
I apologize.
great. Okay. All right, we're on the record then in Dalton versus Dalton, case number 2414396. The record should reflect that all counsel and both parties are all present by Zoom video here today. This is set for a pretrial hearing. I believe this is our first meeting. And so Ms. Lentz, on behalf of plaintiff, how did you want to proceed today in terms of scheduling?
I believe Ms. Neros and I will be pretty amicable to working out dates for discovery and whatnot. I believe the parties still need to exchange their domestic relations verified financial information form. So I would say maybe Ms. Neros 60, 90 days for discovery.
Yeah, I think 60 would be fine. I know I have my client's form for Attorney Lentz, but I don't think there's a need for extensive discovery here.
And I will be snagging Kelly's signature after this concludes today. So I should have that to you shortly as well.
Okay, and I don't know how large the marital estate is here, but do you want to have community mediation? Do you both want to agree on a mediator? How did you want to proceed in that regard?
I would be comfortable with Attorney Neros and I selecting a mediator from like the court approved list or just on our own. I don't think that will be an issue, but I know my client and I are open to mediation.
Okay, Ms. Neros?
I would echo that sentiment. I'd prefer to pick a mediator rather than use community service. I've had the best experience with them.
Okay. So I'll just put in the order that the two of you will agree on a mediator, and I'll just ask that one of you notifies the court of your selection once that's made. And if we set a deadline for mediation at 90 days, any objection to that?
No, Your Honor.
No objection.
Okay. And then what I'll do is I'll set it for another status conference following that 90-day period. If the parties are able to agree through mediation, we can use that date as a date to take proofs and enter judgment. And if not, then we can talk about what further scheduling we may want to do to get the matter resolved. Do either of you have any objection to that?
No, Your Honor.
No objection.
Okay. Ms. Lentz, on behalf of plaintiff, any other dates that I can address for you today?
No, Your Honor, I think that's sufficient. I appreciate it.
Ms. Neros?
Nothing for me. Thank you.
Okay, I'll put these dates into an order. I will also get you both a notice of the date and time for that status conference pro-con hearing following mediation. And we'll go from there. Everybody's free to disconnect. Thank you.
Thank you, Your Honor.
Okay, whoever's connected by phone, can you tell me your name, please? Are you able to hear me? Okay, for the record, we did have another hearing set at 2:30, and that was a divorce matter, case number 2414388. And we do have somebody connected by phone. It's a 231 number, but it doesn't identify a name, and that person obviously is not either not able to hear me or not able to respond. I don't know if that's somebody signing in on that case or not. So at this point, the court's simply going to adjourn that hearing. That was a motion for entry of a default judgment of divorce. And the court will reset that for a hearing next month. And if nobody appears, the court will consider dismissing that case at that time. That concludes our afternoon docket. The court will be in recess until 9 a.m.